me get on to introducing our special guest this evening. Toby Young's a journalist, author, and one of Britain's most effective campaigners, especially around freedom of speech. He founded and runs the Free Speech Union, a trade union I heartily approve of and would invite you to join. We'll make sure there's a link to that in the chat if you're not already a member. If you haven't heard of the Free Speech Union, where have you been and what rock have you been living under for the last few years? It's a non-partisan organisation defending individuals facing censorship or professional repercussions for their opinions. Toby's also an associate editor of The Spectator, where he contributes commentary on politics and culture. He's the founder and editor-in-chief of the Daily Sceptic, a must-read political blog and newsletter and website known for publishing viewpoints that challenge the orthodoxy on issues such as COVID-19, climate change, and a range of other issues. Toby was ennobled by Kemi Badenoch in 2024, so now sits as Lord Young in the House of Lords and dedicates a good part of his busy life to the work of the Lords, and he is also one of the most effective advocates from the Conservative benches there. Toby, great to see you, my friend. How the devil are you doing?
I'm good, Mark. I'm good. Good to see you. I'm going off to see Southampton tomorrow.
Yes, well, I'll see you there. Clash of the Titans, Saints versus QPR.
Yeah, have a drink beforehand.
Definitely. So, look, I said just before we came on air, Toby, I can't really think of much I disagree with you on. So I'm going to play a pretty firm devil's advocate, right? I'm going to try and put myself in the shoes of someone who thinks you might have got it wrong, at least in part, or at least on some nuances. But I want to start by asking you, can you kind of sum up the state of free speech in Britain today? Is it worse than ever? Is it just different to what it used to be because we've got so many social media platforms? So the sort of things, it's easier to track down what someone has said. What's changed? Should we be more concerned in 2026 than we might have been in 2006 or 1986, for example?
Yeah, I think things have got worse over the last 25 years or so. I think a combination of the woke mind virus and social media have contributed to a pretty censorious climate, as well as a big uptick in the number of people being arrested under suspicion of committing various speech offences by the police. And I can give you chapter and verse on that perhaps later in this conversation. And this government is in the process of making things worse on an almost daily basis. Keir Starmer, when challenged about the state of free speech in Britain, in the White House, in the Oval Office, said that we had a long and noble tradition of defending free speech, of which he was very proud. But certainly there's little evidence of that in the way he's been governing the country. The latest outrage, Mark, and I can give you a very long list, but the latest one is today the government has laid an amendment to the Crime and Policing Bill, which will significantly increase the number of aggravated speech offences you can be arrested for. So they're turbocharging the hate crime framework in a way which wasn't, at least not entirely, in the Labour manifesto. So that's a looming battle in the House of Lords, but one of many.
Tell us a little bit about that, Toby. So give our audience some sort of example where you might say something possibly even a little off colour, possibly not, that puts you on the wrong side of the law without committing a crime. I thought all these hate crime offences were to do with an aggravation of a crime. You punch someone in the face whilst spouting racial abuse about them or some such like. But what might you just say, simply an oral or written statement that could land you in meaningful trouble, that you could have plod at the door?
Yeah, a good example is a recent-ish experience suffered by Helen Joyce, the gender-critical feminist, former Britain editor of The Economist, has a PhD in maths, wrote quite a celebrated book about the kind of gender wars. She was on a panel at your former hunting ground, the IEA, with a trans woman / trans rights activist called, I think, Frida Wallace. And in the course of the discussion and subsequently, Helen Joyce misgendered Frida Wallace, i.e. called Fred by his correct biological pronouns. And another trans activist called Lindsay Watson, who was also behind Graham Linehan's arrest for 3 tweets at Heathrow by 5 armed police officers earlier this year.
No.
That activist complained to the police about Helen Joyce's misgendering of Frida Wallace and said that Helen was guilty of criminal harassment. The police recorded it as a crime, but didn't charge and didn't recommend to the CPS that Helen Joyce be charged, and didn't notify Helen Joyce that she had been recorded as having committed a crime. She only found out, I think, after submitting a subject access request subsequently. Now, what the amendment to the Crime and Policing Bill that the government laid today will do, amongst other things, is it will make certain crimes aggravated by hostility towards transgender identity aggravated offences. So that means that they're more serious offences carrying a higher tariff and colloquially become known as hate crimes. So the police decided not to take any further action beyond recording Helen Joyce's misgendering of Frida Wallace as a crime. But once this amendment becomes law, what Helen Joyce was guilty of in the eyes of the police would become a more serious offence carrying a higher tariff. Therefore, I think it means she would have been more likely to have been charged. So that's an example of what the government has done today, which could mean misgendering a trans activist could result in you being charged with a criminal offence. You're right that it doesn't create a new criminal offence. It just makes an existing offence, which apparently it is, according to the police, a more serious offence, and therefore you're more likely to be pursued for it.
Okay. Yeah. And I mean, you're right that many of them have been causes championed by your outfit, the Free Speech Union. But I mean, there are legendary examples of this. I wonder if you could tell me a bit about, I think the government are pledging to get rid of them, aren't they? Non-crime hate incidents. Unlike the case you've just told us with Helen Joyce, this would be a knock at the door for Plod to come in and sort of say, you're acting somewhat aggressively. It's a fairly nebulous sort of discussion from what I gather. You're not actually going to be charged, but you get the policeman in your living room who then make all sorts of comments about, I think in one instance, how Brexity the books were on a gentleman's bookshelf. Would you completely abolish non-crime hate incidents? Is that one of the tools the authorities are using to crack down on freedom of speech? I mean, it seems an oddity to me. We can argue about what the criminal law should be, but it seems an oddity to me in some ways that it's policed whilst accepting that the behaviour is not criminal.
Yeah, it is odd, but I think quite symptomatic of the increasingly hostile climate to free speech. As you say, it's the policing of speech, which by definition isn't criminal. It's policing speech, which is non-criminal. And that, I think, takes us into a very dangerous grey area. One of the sacrosanct principles of English common law, I'm sure you're familiar with, is that unless something is explicitly prohibited, it's permitted. And that's been a cornerstone of English liberty for centuries. This creates a new form of prohibition in which something isn't explicitly prohibited by law, but is somehow prohibited nonetheless. So if a non-crime hate incident is recorded against your name in the National Police Database, and we estimate that about 250,000 have over the last 11 years or so, then that can show up when you apply for a job that requires you to do an enhanced criminal records check. It can show up on your criminal record, the fact that you haven't committed a crime, and prevent you from getting the job. So it does have repercussions, even though you haven't committed a criminal offence. I've tabled an amendment to the Crime and Policing Bill that would effectively scrap non-crime hate incidents, make it unlawful for the police to investigate and record them henceforth. I think we might be making some headway. I mean, the Free Speech Union has been campaigning against NCHIs for as long as it's existed. And I think we're finally making some headway. A report into the NCHI regime was commissioned by the Home Secretary last year. It was carried out by the College of Policing and the Joint Council of Chief Constables. We know that they've kind of submitted a provisional draft of that report. They haven't submitted the final report, I don't think, or if they have, they haven't published it. But in the provisional version, it does describe the NCHI regime as not fit for purpose. So and the government has said it's going to amend the Crime and Policing Bill itself to remove the statutory underpinning for NCHIs. So I think we're beginning to see the collapse of the NCHI regime, which isn't to say it won't re-emerge rebadged to something else. I mean, I think what the Home Secretary intends to do is to say that the police will no longer record non-crime hate incidents, but they will fold the NCHI regime into the antisocial behaviour incident regime, the ASBO incident regime. And this is when you've committed an act of antisocial behaviour which doesn't meet the threshold for a criminal offence, but which is recorded by the police nonetheless. And they will be able to show up. I mean, they can show up at present on enhanced criminal records checks and so forth. But the police have reassured me that under this new regime, the recording threshold will be much higher. So, for instance, to give one example of something that was recorded as an NCHI a few years ago, a neighbour complained that his neighbour whistled the theme tune to Postman Pat whenever he saw him, and that was a racist. It was motivated by racism. God knows how he got there, but anyway, the police recorded that as an NCHI, and the police have assured me that the recording threshold in future under this new ASBO incident regime will be higher. So I then, of course, said, well, does that mean all the existing NCHIs you've recorded will be deleted? So there's no risk they'll show up on enhanced criminal record checks, and they're equivocal about that. So that remains to be seen, and that's one of the things the amendment I've tabled asks the government to do. But I think we are making finally some progress on that front, at least.
Okay, well, I promised to play a bit of devil's advocate. So, is your problem here just that they're recorded, or is your problem that the police shouldn't be doing this? I mean, I imagine sort of back in the day in a kind of Dixon of Dock Green type setting, you can imagine the local police officer, I don't know, seeing a bunch of lads on a street corner who aren't obviously committing any particular crime or offence, but look like they might be up to no good. Perhaps, I don't know, have whistled at a couple of girls who have walked past, giving the impression they possibly had a beer or two too many. You'd expect Plod to go along, wouldn't you, and sort of say, now then, what's going on here, boys? Hope you're not trying to cause any trouble, are you? I recognise you from a few weeks ago. That was sort of policing that we would associate. I mean, I've adduced fiction, Dixon and Dock Green to do it, but that you would consider reasonable. I mean, there's no crime being committed. It's just being alert to something that might flare up. I mean, I would have thought you gave an example of a dispute between neighbours. You could imagine the police coming round and sort of saying, we don't want this to flare up. It's obvious that the people at number 7 and the people at number 8 are getting a bit antsy about each other. Is there anything we can do to calm this down before it comes to blows? Isn't a non-crime hate incident a bit similar to that sort of policing behaviour? I accept there is a difference if it's kind of recorded and in the world of, huge databases rather than the world of Dixon or Dock Green just having his notepad in his inside pocket. It's a bit different. So is that the problem? Or is it that the police shouldn't be involved until they are clear that some crime or other has been committed?
I think, I can see that there are circumstances in which the police intervening when they think there's a risk of a crime being committed before that crime's committed being justifiable. I think the problem with NCHIs is partly that it's taking place on an industrial scale. I mean, if the Free Speech Union's estimates, which are based on FOI requests, not just submitted by us, but by the Telegraph too, that about 250,000 have been recorded since the concept was first operationalized in 2014. That's an average of about 65 a day. And you do sort of think, well, should the police really be spending that amount of time on this sort of trivia, most of which are, people complaining about social media posts they find disagreeable or offensive? The Policy Exchange published a report which estimated the police are spending 60,000 hours a year investigating and recording NCHIs. So, given that they've been around since 2014, that's 660,000 hours. you know, you wonder why, if your house gets burgled or your car broken into, the police won't do much about it. Well, they're far too busy policing our tweets to police our streets. So I think that, you know, it isn't Dixon of Dock Green. It's, you know, it's kind of it's happening on an industrial scale. I think part of the problem is that once you've been, you know, notified by the police that you've, or they don't always notify you, but assuming they do, they give you that courtesy that you've had a hate incident recorded against your name, and it's now sitting in a database and could show up in an enhanced DBS check. I think that does have quite a chilling effect, and knowing that is a risk, I think, has quite a chilling effect too. It's the word hate, I think. People, I mean, and that's one of the ways in which I think the ASBO regime, if the NCHR regime is folded into it, is marginally preferable. At least the word hate won't appear in the records. Of course, you know, being designated as having kind of done something antisocial is quite bad, but it's not quite as bad as it being recorded you've done something hateful. People immediately jump to racism, homophobia, transphobia, misogyny, and you know that's a real badge of shame in today's society. So you know, I think. I think, of course, one of the arguments the defenders of the NCHR regime make is that, well, the police need to record these things for intelligence gathering purposes, you know, to detect patterns, to monitor emerging community tensions,
I
etc.
thought that was sort of the justification, wasn't it? That sort of, you know, we want to make sure that we nip, I don't know, hard right Ku Klux Klan terrorists in the bud before they go and blow something up. And therefore having a kind of record somewhere of people who are sharing or applauding statements or missives from the Ku Klux Klan is probably quite a useful thing to have if you're interested in making sure that you keep a beady eye on something that might emerge as either as an individual sort of terrorist or as some sort of paramilitary organization that you can't quite finger them yet, but you want to gather data about the sort of folk who might be within their general reach.
Yeah, well, my amendment allows for that, in that it allows the police to continue to record incidents for intelligence gathering purposes in the course of an ongoing criminal investigation. But once that criminal investigation has been closed, then they have to delete that record within 3 months. So it allows some latitude to the police to gather intelligence. I mean, one of the things the Met said in the wake of the embarrassment over its arrest of Graham Linehan is that it would no longer investigate NCHIs, but it would continue to record them for intelligence gathering purposes. But you have to wonder, if they're not investigating them, then how much intelligence value does a record of a reported incident really have?
Yeah, okay, I suppose so. Let's move on a little bit. I want to come back to the law at the end of our discussion and sort of what needs to change. Is it police guidance? Is it you successfully amending bills in the House of Lords from the opposition benches, and then perhaps as and when this government is replaced, bringing in future legislation? But let's look at the private sphere now. So let's put aside, you know, the intrusion of Plod knocking on your door and you being recorded for a non-crime hate incident without even knowing it, and this stopping you getting a job. That all seems to me, at least in theory, something that police procedures and a change in the law could solve. Philosophically, though, what's your view of restrictions on freedom of speech in the private sector? A company, for example, that might, I don't know, sell ice cream, but might associate itself with a range of values of some sort, that they're, you know, feel that people should do their bit to lower their carbon footprint, that they disapprove of the state of Israel. I mean, I generally consider it a bit stupid when companies go beyond their core proposition to engage in things which are not directly related to the proposition that they're making to customers in the market. But let's say they do. Are they okay to fire or reprimand employees for saying something out of the workplace that is not simpatico with the values or mission statement of that company? I mean, you know, an extreme example would be, imagine you work for a Christian bookshop, selling the books, collecting the money at the till, but you run a Substack on the virtues of Satanism. right? What would the Free Speech Union say of that? Would the Free Speech Union
Mm.
say, well, look, this Christian bookshop's got a perfect right to sack this person because they're expressing views, albeit in their free time, that are, just don't sit nicely with the overall values and proposition of the company they're working for?
Um, One of the curiosities about this question is that we do come across examples like this all the time in the Free Speech Union, and defend people who are threatened with the sack or placed under investigation because they've said something that supposedly is at odds with their employer's values, or because they've brought the company into disrepute, or because they breached the company's social media policy. But the curious thing is, it's always for saying something conservative, for saying something unfashionable, that's right of centre. It's completely asymmetrical. People never get into trouble for saying something Islamist, for instance, or something too overtly sympathetic to Hamas, or at least extremely rarely.
Is that right? I thought the BMA struck off some doctor who'd said something anti-Semitic.
They did, but that's pretty unusual. We've got half a dozen cases at the moment of nurses and other health professionals who've been placed under investigation by their NHS trusts for attending the Unite the Kingdom rally. We haven't got a single case of anyone getting into trouble for attending a pro-Palestinian demonstration. I mean, I think this points to one of the difficulties, I think, of invoking freedom of association to defend people being dismissed or getting into trouble for speech, for lawful speech, is that back in the day, when the private sector at least provided some sort of counterweight to the public sector, and was small c conservative, you weren't likely to get into trouble for saying something right wing or for saying something conservative. Now, when the public sector and the private sector are much more closely aligned and both are completely captured by radical progressive ideology, it's all one-sided. The only thing, for the most part, there are some exceptions, you get into trouble for are the expressing right of centre views, and that feels unfair. We've thought about this, and we've thought about well, what should the limits be on what an employer can legitimately sack an employee for saying? And we think that, first of all, there should be a statute of limitations. So to frustrate the offence archaeologists, you shouldn't be able to be dismissed for saying something more than a year ago. So people shouldn't be able to trawl through your social media posts dating back to when you were a teenager to try and get you into trouble, as they do. And secondly, if you're going to be sacked for saying something that has supposedly brought your employer into disrepute, damaged the reputation of the company, it should be something that the burden of proof should be on the employer to show that it has actually caused the company tangible harm. I think saying what you've said is at odds with the company's values is too amorphous, too nebulous, too easily weaponized by woke activists. I mean, what we encounter again and again, Mark, is somebody who works for a bank will say they intend to go on the Unite the Kingdom rally, or they're going to vote for reform, or they're thinking about standing as a reform candidate, and they're essentially fired. We think well, why have you fired them? Their justification is, well, they brought the company into disrepute. How do you know that? Well, because lots of woke activists said on Twitter, tagging us in, that they were going to withdraw their custom from our bank unless we fired this person. So we really had no choice. They had clearly brought the company into disrepute. They were damaging the bottom line. It's easily weaponized in that way by kind of groups of activists.
So would you, I mean, very commonly, I'm trying to think of a recent example. I can't think of one, but I can think of one from some time ago. Let's look at people in the public eye, sportsmen or celebrities. They are regularly dropped if they misbehave from being an ambassador for some brand or other, right? Tiger Woods, for example, when he got into a spat with his missus, was suddenly dropped by, I don't know, Nike and Gillette. I may have got the companies wrong, but you get the gist. It was saying, oh, right, blimey. Well, we sort of wanted Tiger Woods because we sort of thought he was a respectable family man. Now turns out he isn't, and he's getting into a scrap with his missus. We are dropping it. And that sort of probably cost Tiger Woods millions of pounds. Would the Free Speech Union have leapt to Tiger Woods' defence there as an unfair ending of his contract with brands who were previously associated with him?
I think it's a difficult one, but I think if we applied our principle, we'd have to say if the brand could show tangible harm, then they would have a legitimate reason for terminating their contract with him. But if not, if it was just in response to pressure from people who disapproved of him, but actually didn't cause any tangible harm to the brand, then yes, it would be unjustifiable.
Okay. Universities, is this for free speech the kind of the worst of it? Is this the darkest spot in British public discourse? Either academics of a conservative bent, basically not existing anymore. It's a tiny proportion, effectively have been sort of hounded out of academia, or as you say, there might be a chilling effect on academics of a right of centre viewpoint, but also student unions intervening and saying, I think the last one I heard was Sarah Pochin had been stood down by Bangor University from some sort of debate. Again, my question there is what do you think the laws should be? I mean, universities are a bit weird because they're sort of halfway between a private and a public space, I suppose. But what do you think the rules should be there on, who a university or a university society can decline a platform to?
Well, I think the interesting thing about the Bangor case, and it was Bangor Students' Union that effectively refused to give a platform to Sarah Pochin, I think is that they requested, I think the Reform MP requested a platform. And I don't think anyone has the right to be platformed. So I think it's perfectly within the rights of a student union to decline a request to speak. But where I think it's objectionable is when a speaker is invited, activists kick off, and then the invitation's withdrawn. I think once the invitation has been extended, then the institution has an obligation to honour it, and they shouldn't grant the right of veto to activists. I think,
but is that you'd have some law in place about that, or do you just think that's appropriate etiquette?
No, I think no, the Higher Education Freedom of Speech Act admittedly only applies in England, so it wouldn't apply in the Bangor case. But it's something that the Free Speech Union and others campaigned for and received royal assent in 2023. Of course, the present government haven't activated all of its clauses, and that's an ongoing battle. But the Higher Education Freedom of Speech Act, I think, would make it a breach of a university's free speech duties to no platform a speaker that has been invited. I think broadly speaking, the underlying principle in the Higher Education Freedom of Speech Act is that students, academics, visiting speakers cannot be penalised by a university if they've simply exercised their lawful right to free speech. So, provided what they've said isn't unlawful, then they shouldn't be punished for it. And that was a principle invoked by universities when activists tried to browbeat them into punishing people on the hard left. So when what she called Gopal, the now professor of English at Cambridge, said white lives don't matter, many people objected, and Cambridge University's defense was, no, that's not unlawful. So we're going to defend her right to free speech. But of course, when David Starkey made some infamous comments in a podcast with Darren Jones, he was immediately stripped of all his positions, including a fellowship at a Cambridge college, even though what he said wasn't unlawful. And we know that because the Free Speech went to bat for him when the police opened an investigation into him and Darren Grimes, and the police decided to take no further action. I think the Higher Education Freedom of Speech Act has got it right. And now it's a question of just trying to persuade the government to make sure it's enforceable.
Okay. Yeah, presumably, if you like, wholly private organisations, you'd allow to behave as they wish, right? I mean, I'll admit it right now. PopCon only invites right of centre speakers onto its platform. Um, we might issue an invitation to somebody. I can imagine we could issue an invitation to somebody, and then information would come to light that would lead us to want to disinvite that person, which could be for completely lawful behaviour. It might be that person had switched political parties, for example, might lead us to disinvite someone. You would allow purely private organisations to behave like that, would you?
I think I think it would uh, partly depend on the nature of the private organization. I mean, I think you have to grant much more latitude to political parties, political associations, think tanks, lobby groups. Of course, they must have the right to um, uh, police who they invite, who they disinvite, because it's important to them to make sure that everyone is pretty much on message. We quite often get requests for help at the Free Speech Union from people who've been kicked out of political parties, saying, you know, can you help? My right to free speech has been breached. And you kind of think, well, we think that you have to grant political parties the latitude to do that if they're going to maintain a political line.
Yeah, fair. On who said it, there's an interesting question here from John Strafford. John, thanks for joining us. Goes back a bit to the sort of online stuff. If we allow all speech other than incitement to violence to be used on Twitter, should tweets be allowed to be anonymous, or should people's names be shown? I mean, this is an interesting one. I grappled with this a bit. I'd be interested in your philosophical thinking here. It seems to me that the advent of social media, which I warmly welcome, I mean, it's fantastic by and large. It might have some downsides, but those are out trumped enormously by the huge upsides. But nevertheless, it's getting a bit confusing who the publisher is, right? So if in, say, The Spectator, they print an article from me that libels someone or is in some way criminal, my understanding is that the overwhelming criminal burden would sit, or financial costs would sit with The Spectator for publishing it. I might face some modest penalty for having submitted a manuscript to the editor of The Spectator, but it would have been them who had decided to broadcast that to The Spectator's tens of thousands of subscribers, and they'd be on the hook for it. Platforms like X, it's a bit trickier, isn't it? I mean, I'm a blue check mark on X. There's a picture of me. I go by my own name. If I say something there, who's published it? Me or them?
I think X and other social media platforms do have this legal indemnity whereby they're not considered publishers and therefore not liable for something libelous, defamatory, invasive, etc., published on their platforms. I think the difficulty with making them liable is that they would very quickly cease to be soapboxes in the public square. I think and the fact that the publishers aren't liable means that they have a pretty laissez-faire attitude to who is allowed to join and who is allowed to comment, and that, I think, the net benefit of that, I think, outweighs. I mean, I think that the benefits outweigh the costs. I think
Even cloaking the identity of the people on the platform. I mean, what's the benefit of anonymity? I remember it took me. I got in about 5 or 10 years ago into a Twitter spat with someone who was insisting that I reveal to him all of the donors of the IEA and, you know, who funds you, and I want a full list and blah, 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 blah. And it was only after about 20 interactions that I realized that this guy was not using his real name. His icon was the cartoon character Muttley from Dick Dastardly, and he was called something like Muttley 107. Who are you to lecture me about transparency? I thought, you're not here, right? At least you can see it's me, the Director General of the IEA. You're parading to be some cartoon character. Do you think there should be any distinction there? I mean, I don't want to render Facebook or X or TikTok inoperable. I generally like this massive public soapbox. It does seem to me there's a bit of a difference between an anonymous account. I mean, I would be happy on what about this, that I sort of say, well, I've got the check mark. You can check out that it's me, Mark Littlewood. Consequently, for whatever I say, I'm liable, not Elon Musk. But Elon Musk wants loads of people parading as a cartoon character on his platform. Perhaps he should be liable if he's not willing to identify the people making the statements or incapable of identifying.
I think the argument for preserving anonymity on social media is that some people wouldn't be able to participate. Some people with important things to say, some people with important things to reveal in the public interest, whistleblowers, would not be able to access those platforms if you insisted that they had to do it under their own names. In particular, people living in authoritarian countries like Iran, China, North Korea, they wouldn't be able to post anonymously, and so wouldn't be able to criticize, those regimes. So I think there are, apostates in this country, particularly women, might not be able to post if they had to identify themselves. So I think there are kind of arguments as to good arguments as to why anonymity should be preserved.
And on the social media topic, where are you on the banning social media for the under 16s? I mean, I now get completely confused about what the established orthodoxy is about various different ages of consent, right? We're going to let people vote at 16, but they're not capable of deciding whether they want half a pint of shandy in a pub or and we have to wait another 2 years before they light up a cigarette and then another year before we trust them to drive a car. But well, I mean, I hate when arguments fall back onto the who will think of the children, but it does seem that there probably is some sort of potential, at least prima facie, a problem here, isn't there?
Yes, I think the evidence that social media causes psychological harm to child users, particularly girls, is pretty overwhelming. I've reconciled myself to this, Mark, and I have to confess, voted for it when the Tories proposed a ban on under 16s accessing social media in the form of an amendment to the schools bill. And I think that the case for it is that it will, I think, ultimately decrease the political pressure on Ofcom to censor social media for adults. The kind of impetus behind the online safety bill, the kind of rhetorical argument for the online safety bill was, well, we have to protect children. Children are at real risk of harm on social media. So we have to police the entirety of social media to protect children. If children can't access social media, and we can get into how hard that is to enforce, but nevertheless, in principle, if children can't access social media, then it really decreases the pressure, the political pressure on Ofcom to police social media thereafter. I think there's an issue about where the kind of age gate should be. So in July of last year, social media companies started age gating content that was supposedly unsuitable for children. And that meant if you couldn't prove you were 18, you weren't able to access that content. And that included Katie Lamb making a speech about the grooming gangs in the House of Commons and various other things which clearly shouldn't have been age gated. And when the Online Safety Act was passed, there were these various free speech safeguards included in it. So social media companies were supposed to grant much more latitude to content of democratic importance and journalistic content. So that was much less likely to be removed. There was a much higher removal threshold for that content, but that hasn't been activated yet. So all the takedown provisions in the Online Safety Act have been activated, but none of the keep up provisions. And I recently pulled a letter together to Liz Kendall, Secretary of State at DSIT, to ask her why they hadn't been activated yet, and could she lean on Ofcom to tell them to pull their finger out and activate them. So far, no response. But I think that if we are going to ban social media access for under 16s, then the age gate cutoff, there wouldn't be a need for an age gate anymore. I don't think you should try and age gate content for anyone between the ages of 16 and 18, particularly as it'd actually just be 16 and 17-year-olds, particularly as you say, the government wants to lower the voting age to 16.
But our very own Sam Collins asked this question. So I mean, a lot of the devil's in the enforcement detail here, right? Isn't the only way we could ban social media for the under 16s to require the over 16s to identify themselves? So I would need to show my passport or some other form of identification or some facial recognition that that proves I'm more than 3 times the age of a 16-year-old. And if we do that, we lose all that anonymity thing that you were just praising.
Yeah.
It just seems to me this might end up being a sledgehammer to fail to crack a nut.
Yes, I think that is a risk, but I think that risk is exaggerated. Um, uh, we publish various pieces in the Daily Sceptic by a passionate advocate for digital ID, and he gets very frustrated when the argument is rolled out that there's a risk that our privacy could be compromised, the data could be hacked, etc. And he points out repeatedly that it's perfectly possible to verify your age via a third party. And that third party can then provide you with a means of proving to a social media company that you are over 18 without any risk, without any need to disclose any details of your identity to that social media company. And there are various companies that will play this middleman role, which he thinks, are perfectly capable of securing your details without no need to pass them on indirectly to the state.
Okay, that can be sort of firewalled. I get that. Um, this may be a slightly unfair question to you, Toby, because you're a campaigner rather than necessarily a tech obsessive. But I'm just amazed there isn't a tech solution to this that would revert us back to parental power. Why has nobody invented an app that means if your 14-year-old son's got one of these, they can only use it an hour a day, and whatever they're accessing is immediately copied to the parent's email address or whatever it might be. That things are put on there to block them accessing, I don't know, computer games or pornographic material or whatever it might be. And the person in loco parentis puts, the child safeguard app on their computer, on their mobile phone, on other stuff. And you might have certain legally mandated things, preventing access to pornography, for example. But you could also then empower parents to also say, I don't want my, any website with the following swear words in it. I don't want my child to be able to access. I only want my child to be able to use this half an hour a day and an hour a day at weekends. It seems to me, with the explosion of technology and software, bewildering that such an application doesn't seem to exist on the open market.
No, I think apps like that have been created, and I remember as a parent of 4 then young children, trying to police their social media use via an app of that kind. But the problem was my kids very quickly found a way around it.
Right.
It's like putting parental controls on, your Skybox. They very quickly figure out how to get around them. And it may be that that's going to be one of the difficulties in trying to enforce a social media ban for under 16-year-olds. Maybe kind of, samizdat smartphones will be traded behind the bike sheds. So I think, I mean, I imagine, I think the government hasn't said it's going to do this yet. The government has said it's going to carry out a consultation about it. But it's going to grant itself Henry VIII powers in the form of an amendment to the schools bill, which will enable them enable the government via a statutory instrument to ban under 16-year-olds accessing social media, if that's the outcome, if that's the recommendation of the consultation they intend to hold. And I imagine the form it will take will be Ofcom fining social media companies who don't make sure that under 16s can't access their platforms. But I think that's probably not the most efficient way to enforce a ban. It would be better if you could enlist the cooperation of the manufacturers of mobile phones. So I mean, you could imagine, Apple could include a kind of facial recognition tech on an iPhone, whereby if you couldn't prove, I suppose people could hold it up to adults, but I think it would be much easier if you enlisted the help of the manufacturers of the hardware to enforce a ban like that. I mean, it could just be, it could be that you're just not allowed to sell a smartphone to anyone under 16, and if they do end up purchasing them, then that's on you, Apple.
Right. But as you say, you'd get a secondary market, right? That's the problem.
Yeah.
We've got quite a few questions, Toby, which I want to turn our attention to about sort of what is to be done here. And really interesting question from Matthew Ilsley. Good evening, both. From a legal perspective, how badly do you feel free speech has been affected by the judiciary system adopting ECHR as a primary tool of use in the past 25 years or so? Valerie Coker, good evening, Valerie. She says, today I read of a nurse who was suspended because she addressed a large bearded man as Mr. He said he was a trans woman, didn't want to be called Mr. What can be done to end what most people think is nonsense like this? Simon Deere asks, with the abuses being perpetrated by Starmer and co, what legislation do you suggest is required in order to restore freedom of speech in the UK? Do we now need a statutory Bill of Rights? So this is what I'm really interested to hear your thoughts on, or whether Free Speech Union has a position. Are we just like permanently involved in a war of attrition that, as Churchill says, the price of freedom is eternal vigilance? Or are there certain pieces of our constitutional framework that we should cherish, perhaps even including parts of the Human Rights Act? Or do we need to draft some other version of that? Because our principal claim at PopCon is that we need to get back to parliamentary sovereignty, and we've handed over too much power to the judges. The rule of law does not mean the rule of judges, and we have far too many independent quangos that are wielding political power. So let's give power back to Parliament. But I'm conscious that that might not be, at least in your mind, the best way of defending individual rights. Do we need something like the American First Amendment? So I appreciate you're playing defense at the moment, right? You're trying to amend Labour legislation, but do you have in mind a kind of framework or blueprint of the legislative or constitutional framework in Britain that would protect these kind of core rights, rather than us relying on Toby Young and the Free Speech Union and future Toby Youngs to be permanently alert to the dangers?
Yes, I think relying on the Human Rights Act and the European Convention of Human Rights is that the right to free speech, Article 10, is heavily caveated. It's nothing like as robust as the First Amendment, and therefore hasn't been as helpful as something like the First Amendment would be when it comes to protecting our free speech. It hasn't been useless. Sometimes when, Christian street preachers are arrested, they overturn their convictions or win in the magistrates' court by appealing to Article 10. So I would like to see a much more robust law that we could rely on to protect free speech, something much more like the First Amendment. I mean, one solution I advocated facetiously in The Spectator the other day would be to come out of the ECHR, repeal the Human Rights Act, and replace the Human Rights Act with a new Act of Parliament, which gave effect to the first 10 amendments of the American Constitution, including the First Amendment in British law. And that would be sort of stage one.
We can have guns as well.
Well, the Second Amendment would be, have guns as well, which incidentally was based on a right that did exist under English common law for a long time. But I think the like you, I want to see the principle of parliamentary sovereignty restored, and so I think trying to think of ways to fetter future parliaments. If you were able to, introduce a free speech law and you wanted to give it some kind of constitutional authority, make it hard for future parliaments successor parliaments to repeal it, I'm not sure that would be consistent with a commitment to restoring the principle of parliamentary sovereignty. And I don't think it could be done either. I mean, people come up with various schemes all the time and suggestions, but, if you regard the principle of parliamentary sovereignty as sacrosanct, then no parliament can bind its successor. So there wouldn't be a way of giving something like the First Amendment in British law a kind of inviolability, the kind of inviolability it enjoys in the United States, because it's the First Amendment of the Constitution. It's quite difficult to amend the Constitution. But I think there would be various political things you could do. I mean, if you think about the Equality Act, that doesn't have any kind of constitutional supremacy.
But I'd like to repeal it.
but it's very hard to repeal. I mean, it wasn't repealed by any governments that succeeded Gordon Brown's
Yeah.
administration. And Suella Braverman's come slightly unstuck by announcing that she wants to repeal it if Reform form the next majority government. So if you
How's
could,
she come unstuck? How's she come unstuck by
well,
that? Do the
slightly
Conservatives not
unstuck.
want to repeal it?
Only by finding it tough to answer questions about what kind of discrimination currently disallowed by the Equality Act would she find acceptable? Would you allow employers to discriminate against black people, against gays, against women, and so on and so forth? I mean, I think and Zia Youssef has come up with a kind of middle ground position, which sounds awfully like the Equality Act. So I think it's Harriet Harman and others managed to sprinkle the Equality Act with a kind of political fairy dust, which made it very difficult to repeal. So I think we need to study exactly what they did and replicate that when, God willing, we're in a position to pass something like a Free Speech Act, which brings something like the First Amendment into effect in British law. I think that's got to be the way forward. But I don't think we should try to tether the sovereignty of future parliaments beyond that.
Okay. Toby, I want to finish on another area of our ancient and precious liberties that's not specifically around, I suppose, freedom of speech, but I know is an area that exercises you and indeed many of us across the political spectrum. David Lammy's plans to withdraw jury trials and allowing magistrates to sling you in prison for, is it up to 3 years? Is that his plan, I think? Why should we be worried about this?
Well, one reason to be worried, Mark, if you're fond of free speech, is that we carried out some research at the Free Speech Union and found that where someone is accused of a speech offence and just appears in front of a magistrate or a judge, they are much more likely, significantly more likely, to be convicted than if they appear before a jury. We had a great case involving a former Royal Marine called Jamie Michael.
Yes, this is a famous one. Yeah.
Yeah, so he was accused of stirring up racial hatred because of a video he posted on Facebook, 15-minute video in the immediate aftermath of the Southport attack, and was charged with stirring up racial hatred, completely wrongly, I think. And it took a jury all of 17 minutes to unanimously acquit him. I think juries are a good check on the authoritarian impulses of the CPS, of the Director of Public Prosecutions, the government. So fewer jury trials means more authoritarian sentences being handed out. So I think there's the argument for restricting the right to trial by jury is also extremely spurious. We need to do it to stop to sort of unclog our kind of criminal justice system. The delay, justice delayed is justice denied, and so on and so forth. I mean, there are much easier ways which don't involve breaching fundamental constitutional rights to unclog our criminal justice system. I mean, you could just make the courts more efficient. They could sit more often. You could, I mean, for instance, one of the reasons criminal trials quite often get delayed is because the police van bringing criminals to court from where they're being held on remand are delayed, take too long to get there. So the trial has to be postponed. And that's because they're not allowed to use bus lanes. So that would be a pretty simple fix.
Yeah.
But there's I think, as someone I've done jury service twice now, there's even though when you're called up, you think, oh my God, what a colossal chore. How am I going to fit this into my busy life? Think of all the money I'm going to lose because of the time I'm going to have to spend sitting in a courtroom. But actually, it's one of the few opportunities you have to kind of become a real participant in civic life and come to grips with your responsibilities as a citizen. It's a salutary reminder, I think, of the responsibilities of citizenship and what you owe to your society. And I think people, in my experience, 2 times I've done it, take it very seriously. They want to make sure that they don't convict someone who might be innocent, or don't let someone free who's obviously guilty.
Do you think we've, if you like, the cat's already out of the bag? We've allowed already too much power to magistrates, or indeed, Jeff Townley asked this question, that the law has become so complicated in so many areas, or at least the amount of evidence that we can now rely on. Jeff Townley says, I do think that some trials should only be judged by experts, e.g. complex financial and business frauds. Or if you were to take, say, the Lucy Letby trial, I mean, how many months was that in court? It seems that
she pleaded guilty, unfortunately. So that's
no, Lucy Letby, not Lucy
Oh,
Conley.
sorry, no, I thought you meant Lucy Conley. Yeah, Lucy Letby.
So,
Yeah,
a complex trial with, I mean, I appreciate, it was very serious, but was it 10 months in court or something? I mean, unbelievable obligation on a juror. And the magistrates can already lock you up for, is it 18 months? I can't remember. So won't they just, if they want to lock you up for untoward speech, just accept that the maximum sentence you're going to get is 18 months rather than 3 years, bend it that way round? I mean, would you want to see jury trial extended, or do you think we've hit the Goldilocks spot? We've got it about right between magistrates and jury trial now.
Yeah. I think I would, in an ideal world, I would like to see everyone accused of a speech offence have the right to trial by jury. So make all speech offences either way offences.
Mhm.
I think there is a case in incredibly complicated cases such as fraud. Sometimes when people are accused of libel, something like medical malpractice, nurses accused of murder, etc. Then maybe there is a case for having just judges decide on the outcomes. But I think we shouldn't underestimate the man on the back of the omnibus and his ability to get to grips with these complicated issues, and have a kind of reliable gut feeling for whether someone is guilty or innocent. I think a lot of the arguments for scrapping trial by jury do depend upon kind of this rather jaundiced kind of contemptuous view of the abilities of the ordinary man in the street, and people who generally are opposed to trial by jury or want to restrict it, not very keen in democracy in all its forms.
Yeah, and I mean, I'm rather with you that the idea that we're going to toss out an ancient liberty that we've stood by for hundreds of years because we've got a bit of an admin backlog seems to me utterly pathetic. Let me just finish by asking you: do you think we're going to win on this one? Or do you think David Lammy is going to win?
It's interesting, isn't it? You'd think that they would have U-turned on it by now, given how many other things they've U-turned on.
The only thing they really care about is abolishing jury trial and giving away the Chagos Islands. Everything
Yeah,
else,
those
they're
are
willing to
the
U-turn
only
on.
things they're going to die in a ditch about. Yeah, it's it might be that David Lammy. I mean, the odd thing about it is this is a proposal that senior officials in the Ministry of Justice have tried to foist on, every justice secretary for decades, seemingly, making the kind of admin backlog argument, and they've all resisted it, apart from Lammy, who's now absolutely embraced it, owns the policy, and is prepared to die in a ditch about it. It's bizarre, but yeah, I'm hoping that they will U-turn on it, or if not U-turn, do a partial U-turn. I mean, the fact that it is so, I mean, there's almost no one in the entire criminal justice system, apart from the Justice Secretary, who's in favour of this, and maybe Lord Leveson. But you talk to judges; they don't like the idea. Most magistrates don't like the idea. None of the bar associations in England, Wales, Northern Ireland, Scotland like the idea. I mean, it's
you
got
can be
almost
sure most defendants don't like the idea. All right.
No, defendants in speech cases, yeah, they certainly don't like the idea. Yeah, so yeah, it's you would hope that the government will eventually be pragmatic about this, but as you say, it's odd the things they decide to die in a ditch about.
Toby, it's been a fascinating discussion. Thanks so much. More power to your elbow. Amazing what you've achieved, especially with the Free Speech Union. I mean, epic and heroic work. So thank you very much indeed, Toby. Thanks
Thank
to
you.
all of our audience for joining us this evening. We've had a huge number of you on the online Zoom call. I presume you're all signed up to Popular Conservatism, but if not, go to the chat box and make sure you receive our weekly newsletter. That's the best way of hearing of our upcoming bricks and mortar and online events. Just to let you know, our next Pop Conversation will be on Monday, the 9th of March at 7 p.m. That's with Andrew Rosendale MP, who has recently defected from the Conservatives to Reform. The following week, on Monday, the 16th of March, also at 7 p.m., I'll be joined by Douglas Carswell from the great state of Mississippi to hear his thoughts on what's going on both sides of the Atlantic. So thanks very much for joining us. We've had a great turnout today. Sorry I couldn't get through more of your questions. We will package up your comments and make sure they are sent to Toby, even if I wasn't able to put them to him direct. Have a great evening. Keep the flag of freedom flying. Over and out.